motion, and we have a vote. Now it's time to turn the meeting over to our attorney from Moses Lake. One of his specialties in court district law as it pertains to airports and corporate. Chris Reed, on your feet.
All right, thank you. All right, as Orville said, my name's Chris Reese. I'm here, I think, a little bit to talk about what the port can and can't do, and I know that that, I believe, concerns probably a great number of the people in this room. That's why you're at this meeting. The port now is apparently retaking possession of this golf course and needs to figure out what to do with it going forward. The port has very limited authority as opposed to a private company or a private club on what it can and can't do. The only way the port can own and operate this golf course is if we can shoehorn it into what they call a tourism-related facility. I'll back up a little bit. The port, like any other government agency, only has the authority that the legislators over in Olympia have given them, and the authority here is limited to running park facilities if those park facilities are related to their port improvements, which essentially means having a park next to a ferry terminal or something of that nature, which obviously we don't have in this particular instance, so we don't fit in that statute, or if we can call it a tourism-related facility. The statute doesn't really define what in the world they mean by a tourism-related facility, and there's a whole lot of case law out there about what they mean. I'm going to guess that most of the people in this room are probably local area people, so it would be hard to describe any of you as tourists. The golf course and the use by local residents isn't obviously associated with tourism or related to tourism. We can make the contention that the golf course does bring people from outside areas in to play golf, and I'm certain that's the case. But it isn't real clear as to whether we'd be able to necessarily shoehorn this thing in as a tourism-related facility, simply because I don't have any guidance on it. There is no case law on it. There are no statutes telling me what in the world that's supposed to mean. So frankly, I've recommended to the port that what they should do is go out and look for someone, private person, private company, to come in and operate this on their behalf. And I'm not talking in terms of the port hiring somebody as a contractor for the port to operate it for the port's account, but instead to, frankly, try to find someone who will lease the course and operate it. So that the first challenge we face is there. Now that the port has passed a motion to retake possession of it, it can go in and do what it needs to maintain it. For instance, get the water turned on because it's going to need water here shortly in order to preserve the value of the course. But the port can't jump right into opening this course tomorrow or probably even next week. It's got to try to work its way through some of these things and find someone to operate it. And even if it made the election to say, well, we're going to call this a tourism-related facility, and we are going to say we have the authority to operate it, well, then we got to do things like establish rates, greens fees, all the things that go with that. And unfortunately, the port is not as quite as agile as a private club or a private individual. After all, it has to conduct all its business after sending out a notice, such as the one for this meeting, and then holding a meeting. It makes it a little bit slower. Then I think probably the primary reason the commissioners have asked me to be here today is this issue about greens fees, and particularly the fact that, as I understand it, numerous members of the club prepaid dues for 2012 that were then used last September. Here is that one? Last September to pay the 2011 rent payment and other expenses.
The rent payment, the leaseholder's tax, the land assessments, and the water bill.
But that was all for 2011 and not for 2012.
Nothing for 12. So
essentially, people were asked to advance 2012 dues to catch up 2011 expenses. And now what do we do? And I know that the commissioners have expressed to me that they would like to honor those dues. And I get to play a little bit of bad guy here, frankly, folks, and talk about what authority they have. The port is not the one, of course, that collected those dues. The club did. And the club used those, indeed, to pay a club expense, but it was a club expense associated with 2011. It was simply catching up what happened in the past. Frankly, the port has no obligation back to those individual club members, not legally speaking, and I have to obviously focus my attention on legal obligations as opposed to what one might say a practical or moral obligation. They don't have a legal obligation to honor those dues. So if they do elect to honor those dues, because I think everyone can be sympathetic to that situation, I am, and I know the commissioners are, but if they do elect to, if they don't have, or elect to honor them, if they don't have a legal obligation, then it's gratuitous. Ultimately, the law looks at it as, then it's a gift, if you don't have a legal obligation. And the Washington Constitution absolutely bars the port, and every port in the state, and in fact every other municipal corporation in the state, from gifting public funds. I'm sure everyone can appreciate why you wouldn't want your elected officials gifting public funds to anyone, but that has an impact in this particular scenario. If it's gratuitous, we can't do it. And so although the commissioners asked me to find a way to do it, there is simply no way to honor the dues that people have paid to the club. Now, does that necessarily mean that if we can find someone to come in and lease this place on the cheap as it's been leased in the past, if we can find someone to operate it, that they couldn't honor it? Well, of course not. If we can find a tenant to come in and take over the thing, then they're welcome to work whatever arrangement they might with their customers or members or however it is they choose to set the thing up. But if the port elects to operate this thing, or as it ends up, maybe the port's left as the only one who will operate it, they are absolutely legally prohibited from giving free memberships or annual greens fees or anything else to any particular individuals, or even charging them necessarily a different rate. And it goes back to the due process things. They got to treat everybody the same. And so that is the scenario we got. And I think the commissioners wanted me here to explain that, as well as to field any questions that anyone might have. I think the commissioner's support has a whole lot of issues they got to deal with between now and getting this club open, whether it's under the mantle of the port or it's under the mantle of a tenant, insofar as determining what equipment's out there, what's the condition of the equipment, what equipment's going to be left for with the course. I'm told that we've got some tax lien situations out there that the state's asserting some tax liens against some of that equipment that belong to the club that are going to have to be addressed. So we got a whole lot of work to do before we'll even really have a sense for what options we have to go forward and get that course open. Please.
When you talked about the maintaining the course at this present time, turning on the water, I suppose leaving power to the cart barn when people have their carts out there, is that the steps that would be taken in that area?
Yeah, well, obviously we don't want the greens to die. Under any circumstances. Got to keep them alive, whether people are playing out or not. We don't want the place lost.
Sure.
We can't have things freezing up out there. We got to maintain the property, absolutely.
Well, those of us who have like golf carts stored out there that are electric that have to be maintained, will electricity still be on?
It has to be by, otherwise it can't be insured.
Oh, okay. So if we got cars and stuff like that, they're good the way they're at right now.
For right now, absolutely.
For right now, well,
Yeah,
I understand that. I was just trying to make that clear.
Yeah, well, once again, obviously they'll have to be addressed, but for the time being, we need to let the dust settle and figure out where everything's at and figure out how to get this thing moving forward.
So I don't have to move it tomorrow is what I was trying to say.
You don't have to move it.
Does Quincy operate under this tourism umbrella that you talked about? And are you familiar with how they work? I believe the court is sitting on the golf course in Quincy.
I so happen to be the attorney for the Port of Quincy, yes. And that is the only authority for a port to own and operate a golf course, with the exception if you put a golf course next to your harbor improvements. I suppose that might work down in Crescent Bar if that eventually falls into possession of the port, but that's not the case.